Heck yeah. Finally, a win that hits the anti-gun crowd where it hurts. We have some truly significant news coming out of Pennsylvania that's sure to stir the pot regarding the right to bear arms. This is no small update. It hits like a bolt of lightning. A state-level appeals court has just turned over a huge chunk of Philadelphia's long-standing policy on carrying firearms. This decision will be making waves from coast to coast. We're talking about a local rule that has been used to charge regular folks just for openly carrying a firearm where it could be seen. No threats, no harm, just lawful open carry now officially considered unconstitutional. Stick with me as I walk you through what went down, why it matters beyond Pennsylvania, and why lawmakers focusing on gun control just got a serious heads up. Here's the full story. A man by the name of Mr. Sumpter was walking along a Philadelphia sidewalk, much like countless responsible Pennsylvanians do daily. He was minding his own business and was carrying his legally owned firearm visibly tucked into his waistband. He wasn't bothering anyone. No crime was committed. No altercations happened. He was merely exercising what he believed to be his inherent and constitutional right to carry arms. However, being within Philadelphia city limits meant he was treated differently. Law enforcement saw his firearm and arrested him under a city law known as Section 6108. The issue starts here. This regulation makes it illegal to openly carry a firearm in Philadelphia without a carry license, but here's the key. It's completely legal throughout the rest of the state for any responsible adult over 18. This law doesn't focus on what one does, it targets where one does it. If Mr. Sumpter had been just a block or two outside that invisible city line, he wouldn't have been arrested. Yet within Philadelphia, openly carrying a gun became a legal problem. That arrest led to a conviction, sparking a legal battle now reaching a critical junction. What started quietly has turned into a pivotal legal struggle. Because Mr. Sumpter decided to fight back instead of settling, the court had to face some tough truths. The law didn't apply evenly among citizens. When a rule causes unequal treatment of rights, it doesn't hold up. Now here's where it gets noteworthy. The court didn't mince words. In clear language, they dug into Section 6108, calling it an unjust rule that unfairly targets folks in Philly. They made it clear that constitutional rights don't change based on location. The Equal Protection Clause in the 14th Amendment ensures equal treatment under the law for all in similar situations. This law, by contrast, made exceptions for those in Philadelphia, stripping them of rights others in Pennsylvania freely enjoy. The court stated plainly, open carry is legal in Pennsylvania for any adult over 18 unless you're in Philadelphia. Step into the city, and suddenly, the same lawful behavior becomes a criminal act without a separate licensing effort. That's not just random. It's the definition of unequal protection. When judges use strict scrutiny, the toughest level of review, the state's argument fell flat. Officials pointed to crime stats to defend the law, but the court made it clear that fear cannot nullify fundamental rights. Judges can't bend the rules of the Second Amendment every time someone in the city gets uneasy. The balance between freedom and safety was decided long ago by the founders with the Second Amendment. The ruling was heavily influenced by major cases like District of Columbia versus Heller and New York State Rifle and Pistol Association v. Bruen. The message was unmistakably clear. Cities can't suspend your rights just because they're more crowded or have higher crime rates. If that were allowed, then every city could twist the Second Amendment or dismiss it entirely. Rights don't vanish moving from the suburbs to city blocks. The court emphasized that Section 6108 unfairly disadvantaged Philadelphia residents regarding a fundamental liberty. The phrase special disadvantage captures what gun owners have said for years, that local regulations often sidestep the Constitution under the guise of safety. This time, the court didn't look away. They declared the statute unconstitutional, reminding folks nationwide that local rules can't override the Bill of Rights. Here's why this ruling carries weight. It wasn't based on fringe interpretations or crafted to fit a particular agenda. It was rooted in equality, constitutional history, and clear law. The judges did what they should. They followed precedent and let the rule stand or fall on its own. Section 6108 fell short. That's why this decision impacts the gun control push so deeply. They can't accuse the court of overreach here. The bench didn't forge new paths. They merely adhered to the guidelines set by Heller and Bruen. They went through the legal history, applied the necessary standard, and Section 6108 didn't measure up. Perhaps the most striking part of the decision was the court's acknowledgement of the law creating a special disadvantage for Philadelphians trying to lawfully carry. Such legal wording isn't thrown around lightly, opening up potential challenges against other location-based restrictions targeting residents based on income, population, or simply geography. And don't think the court glossed over the city's safety concerns. They dismantled them. The judges firmly reminded the state that the debate over liberty versus fear was settled over 2 centuries ago when people chose freedom and enshrined the Second Amendment. That choice doesn't get undone because of City Hall decisions. This ruling is about more than a local outcome. It reinforces the Second Amendment. It asserts that rights don't shrink when buildings loom closer or when local officials feel anxious. This wasn't a victory for just one person. It's about millions who've been told their rights don't extend into the city. Now they've got judicial backing. Now they've got precedent. And now things are shifting. For years, major cities have played a risky game. They've crafted loopholes and pointed to stats, hoping courts would ignore the nuances. Philadelphia, New York City, Chicago, San Francisco all followed similar strategies. Push boundaries, try limits, and expect ease for being urban. But now, the Pennsylvania decision changed all that. Section 6108 is gone, along with the assumption that rights can be confined within zip codes. The court's decision was a loud reminder. You can't treat the Second Amendment like it's less valid in cities than in rural areas. Your right to carry doesn't dissipate stepping from private ground to pavement. For too long, big city policymakers have used terms like community protection as shields to subtly take apart individual freedoms. They argue densely populated regions demand stricter control, that more people justify fewer rights. But this time, the court didn't fall for it. They saw through these claims and identified them as constitutional breaches masked as policy. The ruling targets an old belief in the gun control narrative, that a bigger population means higher danger, justifying tougher laws. The judges pointed back to the Bruen decision, reminding officials everywhere that rights don't simply fade in urban areas. No historical basis exists for disarming responsible citizens just because they're among skyscrapers. The Constitution doesn't permit zones where freedom becomes a casualty to fear. What this ruling does is dismantle the myth that cities follow different constitutional rules, sending a clear warning to lawmakers nationwide. Policies driven by fear, not facts, will fall in court. If you rely on emotion over historical evidence, expect courts won't be patient anymore. This wasn't just a step forward for one individual or a rejection of one rule. It sparked momentum capable of sparking greater legal change. What began in Pennsylvania is likely to spread across the states. Why? Because once any court declares a law like Section 6108 unconstitutional, it prompts countless other voices to rise. Every gun owner under similar jurisdiction now has a new path to challenge restrictions. And this has many urban governments concerned. For years, places like New York, Chicago, Los Angeles, and San Francisco operated as if their urban structure gave them leverage to trim fundamental rights. But here's the reality. The Constitution isn't elastic for traffic, crime, or population size. Your rights don't shrink by crowded streets. Liberty can't be redrawn. This ruling offers Second Amendment supporters something crucial: a firm tie of gun rights to equal protection under the 14th Amendment. It's no longer just about carrying arms, it's about being treated justly compared to others miles away. And if the answer is inequality, then it's a court's issue to address. This puts pressure on lawmakers, especially state ones, to rethink targeting a specific city while others go unaffected. A patchwork of fading rights at city limits isn't viable anymore. What truly matters now is the set precedent. When a court establishes a boundary, others take note. It creates a legal shift, leading to many ordinances built on shaky grounds being reconsidered. The path forward is litigation, scrutiny, and dismantling any law that places city folk at a disadvantage in gun rights. The underlying message? Governments must respect the Constitution, even when inconvenient. The document they sidelined is now shaping their limits. This Pennsylvania ruling isn't just a local achievement, it's a shift nationwide. It fuels a movement gaining ground for years, a fight resisting boundaries, changing rights. From here on, expect judges to ask tougher questions, laws to fall, and freedoms restored. As courts step in, the system begins self-correction. Thanks for sticking with this to the end. Staying informed matters. Your input holds value. Do you see this ruling as hopeful for wider change, or does it bring more to ponder? Share your thoughts below. Your engagement is crucial in these steps. Until next time, stay sharp, stay ready, and most importantly, stay free.